number 36, Columbia Memorial Hospital versus Hinds. Counsel?
Good afternoon, Your Honor. My name is Andrew Zwerling of Garfunkel LPC. I'm appearing on behalf of the appellant, Columbia Memorial Hospital, and with the court's permission, I'd like to reserve 2 minutes for rebuttal time.
You may have 2 minutes, sir.
Thank you, Your Honor. Although analysis of Insurance Law 7307 results in the conclusion that where an employer paid the premiums, it is entitled to receive the Milnick Conversion Fund, as all 4 appellate divisions have held, and as the Department of Financial Services, DFS, essentially concluded, the determination of which party is entitled to the Milnick monies rests on equitable claims of unjust enrichment. Specifically, we submit that the issue of which party is entitled to the Milnick monies should be decided on the basis of which party has demonstrated attributes of ownership and on the basis of facts demonstrating the expectations of the parties with respect to ownership of the policy.
Counsel, here. The insurance law is a very complicated thing, and there's a very specific provision here which governed during the relevant time period. So we could do what you want to do and say, you know, look at these cases and look at what they thought and look at the equities, or we could say there's a very specific, and to get to the unjust enrichment here, we have to say the statute goes one way, but we're going to go the other way. So we say the statute says this, but we're going to find that you can litigate unjust enrichment claims based on the fact that 2 parties enter into agreement with a governing insurance law statute on a claim that we should look underneath that and see what the equities are in a particular case. Why would we ever do that, particularly in the insurance field?
Understood, Your Honor. And our position is, regardless of how the court falls with regard to the statutory analysis, the hospital's equitable claims survive for a number of reasons. Number one, DFS, the agency that is charged with interpreting the insurance law, in no way found that the entitlement to the Milnick monies was solely dependent upon the insurance law, and in fact did the opposite, created this dispute resolution process where it stated that the resolution of the claim should depend upon the facts and circumstances surrounding the relationship of the parties as determined by applicable law and as determined by a court or an arbitrator.
But again, as the appellate divisions, I think, have found, at least 3 of them, that applies to a very specific situation, arguably, where there was a potential assignment of rights. And so, in that case, there's provisions for these contingencies. But in a standard case where the hospital, let's say, is paying, the doctor's the holder of the policy, why would we look beneath the insurance law for the answer?
Well, I'll answer both questions, which are tied together, Your Honor. First of all, with respect to the assignment of rights factor that the 3rd Department found so important. In fact, DFS explicitly rejected such a bright-line test. I mean, that's the agency that's charged with the responsibility of defining and interpreting the insurance law. DFS explicitly rejected a bright-line test that says you either assign the rights or not, and in fact said that even in instances where a policy administrator has not been specifically designated by the policy holder to receive those monies, that the policy administrator still has rights to contest and challenge that it has a legal ownership right to those monies. Likewise, Milnick in the Milnick conversion plan objection procedure, again, said it explicitly that it doesn't depend upon an assignment, that you can still challenge legal title, you know, regardless of that fact. And it's only logical that DFS and Milnick would not have created this dispute resolution process if resolution of this issue was just as easy as saying you're either the nominal policy holder unless you assign. It wouldn't have done that, again, just, you know, based upon logic. So to answer the question with regard to assignment, I'll now move on to the can we ignore the insurance law? You're not ignoring the insurance law. At the end of the day, even this court has held that legal title does not preclude equitable considerations. With regard to 7307, the language of the statute that Your Honor is pointing to, nothing in that statute precludes the equitable claims from being considered by the court. In fact, the statute...
What does that section refer to?
That statute merely says which party is entitled to receive the monies.
And who does it say?
Excuse me, Your Honor?
And whom does it identify?
It identifies such policyholder who has timely paid the premiums. But with regard to the language, jurisprudence going back over 100 years draws a distinction between the word receive and keep and retain. And even to that point, DFS, in its order and decision, even expressly stated, and I quote, that the release of the escrow, the receipt of the monies by the nominal policyholder shall have no substantive effect on the party's position with respect to who is entitled to the payment under the relevant law. And notably, all four appellate divisions likewise, and I know the court's not bound by the appellate divisions, but all four of the appellate divisions, although they reached different conclusions, went on to consider the equitable claims and didn't feel that there was some firm, rigid prohibition against considering those equitable claims, which only makes sense because, to Your Honor's point, the statute doesn't talk about assignment of rights, which means that the statute itself, the plain language of the statute, does not preclude this court's consideration of variables outside of the statute that should be considered in an unjust enrichment or equitable claim. So I'm not sure if that answers Your Honor's question, but...
It does, thank you.
Okay. And so, most importantly, what we feel is that, as the First Department correctly found in Schaffer, you know, Schaffer's been...
So, counsel, if I can interrupt you, I'm on the screen. Hello, good afternoon. So if I'm understanding your argument, so please correct me if I'm wrong here, your argument really turns on this position that you all paid the premiums. That's what you base your ownership argument on, your equities argument on. Am I wrong about that?
Well, it's incomplete, Your Honor, respectfully.
Okay.
It's not just on who paid the premiums. Essentially, what we're arguing is that if you have a, and I'm not meaning disrespect by looking at Judge Rivera, if you create a ledger or a balance sheet, and on one side you have attributes of ownership demonstrated by the nominal policyholder, and then on the other side you have attributes of ownership demonstrated by, in this case, the hospital or the employer in the other cases. In this column, all the doctor has is his or her name's on the policy because it had to go on the policy. That's not by virtue of any agreement between the parties. But in this case, respondent had no other nexus to the policy that demonstrated attributes of ownership. You know, didn't pick the policy and so on. On the other side of the ledger, the hospital selected the policy. And that's important. In fact, Dr. Hinds, the respondent, gave up that right to select the policy explicitly in his employment agreement. And that's what owners do. They decide what house to buy, they decide what car to buy.
But
Here,
wasn't there a contractual relationship that said you provide this insurance coverage?
Your Honor, absolutely not. And I'll elaborate and be more precise. That consideration claim has been bandied about in a bunch of decisions. Well, the employer, that was part of the consideration in exchange for the physician services. First of all, in this particular case, Dr. Hinds' contract made it explicit that it was not part of his compensation, that the payment of premiums was an expense of the hospital. And with regard to,
But
consideration, no one was promised a million
Counselor,
policy.
is his the one that, if he got a bonus, that was taken into account?
If is the qualifying word here, Your Honor. We are here by virtue of a decision on a pre-answer motion to dismiss, in which the court made this leap based upon an affidavit that was wrongfully considered and based upon Dr. Hinds' statement that he was under the impression that he effectively met those productivity thresholds, which meant he may have paid some of the premiums. But the allegations of the complaint, which was presumed to be true, showed that the hospital, or alleged that the hospital, solely paid those particular premiums.
Okay, but counsel, if I'm back on the screen. Yeah, all right. So counsel, but the insurance protects the doctor, correct?
Yes.
I know it protects you, vicarious liability, correct?
Well, the hospital would have it.
No, but no, because your argument seems to be that somehow there's no benefit at all to the doctor, and the whole point of the insurance is to insure based on the doctor's conduct, correct?
No, Your Honor. And I guess
Right.
to merge the two questions from Judge Troutman and yours is that the only consideration promised to the respondent in this case was base salary, benefits, and a malpractice.
But counsel, could the doctor have worked for you without the insurance?
No doctor by law can
Right,
practice.
so you could not benefit from his labor without the insurance.
But where the distinction, the critical distinction lies, Your Honor, is that the respondent, and is likely true, I can only say likely true in all these other cases, is that nobody was promised a Milnick policy. No one was promised a policy that bore fruit. No one was promised a policy that would pay dividends or have conversion funds. So that stands outside of the consideration. This doctor, in this case, and maybe in all these other cases, received exactly everything that he or she was promised to receive in
Who had to agree under the plan to sign off on the demutualization? Who had to do that? Was it your client?
I honestly don't know the answer to that question, Your Honor, as far as who the specific,
Well, somebody had to sign some form.
I do not know the answer to that particular fact, Your Honor. But again, we believe that,
Well, isn't the doctor the member? Isn't the doctor the one who had to, Dr. Hinds, isn't he the one who had to sign off?
he's the nominal policyholder, Your Honor, so
Didn't he have to sign off?
I do not know the answer to that question, Your Honor. But again, it's a question of weighing who acted like the owner with regard to this particular policy. His name was on the policy, that is it. He had demonstrated no other attributes of ownership. He
Well, wait,
received-
well, hold on. Wouldn't you say that voting for or against the transaction is an attribute of ownership?
Well, there's nothing in the record to indicate whether the respondent in this case voted one way or the other, or voted at all.
No, yeah, but then there's nothing to indicate, generally speaking, who the people were who voted for the transaction?
Well, it may be a requirement of law, but the issue in this particular case, as
I'm
we
just
see
wondering
it,
if you put, assume hypothetically, let's say.
Yes, Your Honor.
That the policy holders were the ones who had to vote. Wouldn't you put that on the ledger that you were talking about on the policyholder side? I'm not
Well-
saying it's dispositive, but wouldn't that be a factor?
it could be a factor, Your Honor. Again, it's a requirement of law that be the case. But again, as between the parties themselves, as far as their expectations as to who the owner was with regard to this policy.
Well, there's sort of a factual finding from the appellate division, I think in two of the cases, second and third departments, that there were no expectations, that this was, in their words, a windfall.
I'm not defining expectations. Look, no party in any of these cases thought, oh, one day there's going to be this demutualization and all this money is going to fall from the sky. Nobody anticipated that. And we're not arguing that when I use the word expectations that that's the case. When I say expectations, it's just how the two parties, in this case, responded in the...
So if no one, counsel, if no one expected that, then why would the policyholder be unjustly enriched? Nobody expected it. So how does it fall to your benefit? Why should your client get it?
As we posit, Your Honor, the hospital, in this case, and likely in these other cases, acted as though it was the owner, took on the obligations of ownership, it selected the policy, it received dividends, which is an attribute...
Yes, but I know, but your whole position, as you explained to me when I asked, when I said, is it all turn on premiums, said, no, it's much more than that. But if none of the things that you referred to are grounded in the expectation of this future money, then where's the unjust enrichment if they get it instead of you?
But at least a couple of those factors are grounded on, with respect to the ownership component, Your Honor. For example, dividends. The hospital received dividends. Why did the hospital get to keep the dividends? Because it was treated by the respondent as the owner and acted like the owner. That's what I meant by the expectations of the parties, or the position with the parties, concerning the parties as to who the owner was. Dividends, the payment of dividends was not a clerical function, as respondent claims,
And why did your client get the dividends?
because, as we're asserting here, is that it was not expressly understood, because that would say that the parties knew that this conversion was going to come down the path, but it was understood as between the parties that this was...
I'm sorry, did Hinds sign it, did they sign it over to you?
The dividends came to the hospital, and the hospital used those monies, which they should not have kept. It should have gone to the respondent if he was the owner, or thought he was the owner. It should have been, give me those monies. But that's not how it played out, which is...
Then what did you apply the dividends to?
To future premiums.
Okay. And-
Thank you,
but
counsel. Thank you, counsel. Counsel?
Hi, my name is Seth Nadell, Weiss, Zarup, Brofman, Sonnen, Clark, and Levy, PC, and I represent defendant respondent Marcel Hinds. Now, I know we talked a lot about the equity argument, but just briefly,
Counsel, I'm sorry to interrupt you before you go further. I'm on the screen. Did the policyholder, did Hinds sign off on the demutualization?
I don't know, standing here today, whether he did. I do know that Insurance Law 7307 charges approval of the demutualization plan with the policyholders. As to Dr. Hinds himself, I mean, I know that the policyholders in general approved the plan. I don't know, I know they had the option to do so through proxy. Whether he himself cast the vote, voted through proxy, didn't vote at all, I really don't know.
Did the hospital vote?
I mean, I can't conclusively say that either, but I can say that under the insurance law, the hospital had no right to vote.
Okay,
And
thank you.
no problem. Okay, so just initially, there's really no credible arguments to be made under the insurance law that the demutualization proceeds belong to any party other than the policyholder, or as the insurance law puts it in 7307E3, the person who had a policy of insurance in the applicable period. The section of the statute that's cherry-picked by the hospital to stating premiums timely paid by the policyholder, as the second and third departments correctly pointed out, doesn't pertain to who the policyholder is, but how the premiums are calculated. So there's really just no merit to that argument. And more generally, from a review of Insurance Law 7307, it's very clear that the overarching concern of the statute is defining and protecting the rights of the policyholder. The policyholder is mentioned numerous times in this statute, and apparently the legislature felt it was so important to protect those rights that they didn't just set forth a roadmap for demutualization and tell the insurer to go forth and demutualize. They actually created an entire regulatory process whereby DFS had to examine the proposed demutualization plan, hold public hearings, accept public comments, and
Counsel, under the law, could the employer be a policyholder?
no, Your Honor, and I was actually getting to that.
Okay.
Because that argument is really premised on a fundamental misunderstanding of the authorities that govern the demutualization. In the technical sense, the language of Insurance Law 7307 doesn't control the demutualization. It merely sets forth the basic parameters for the plan of conversion, which in this case is the controlling and governing authority which governs MILMIC's demutualization. And to the extent that one might identify any ambiguity in the insurance law, such as the hospital is attempting to, it's completely resolved in the terms of the plan. The plan is very clear who is entitled to the cash consideration, eligible policyholders or their designees. And as to your question, Your Honor, could the hospital be the policyholder? The answer is no, because the plan handily defines who the policyholder is, and it's
What
defined.
about your adversary's argument regarding the dispute resolution framework DFS set up?
Okay, and yeah, so the argument is basically, you know, if this dispute was so simple, you know, why have an objection procedure at all? And the answer to that, at least as determined by MILMIC and approved by DFS, is that they knew these disputes would happen and they wanted to have a reasonable framework for resolution which wouldn't hold up the demutualization.
But I guess the question, though, is why we can't read that provision to allow for something other than just formal assignments. That is, why can't we read that procedure to allow for an equitable kind of argument that's being made?
Well, I was going to get to the equitable argument, but really the reason we can't read the procedure that way is because that would not be in accord with the insurance law. The plan of conversion had to conform to the parameters of the insurance law, one of which being that the policyholders and mutual owners of MILMIC were the ones entitled to the money. So the plan wasn't free. It wasn't free to just dispense with this core requirement under the insurance law that the actual owners of the company are the ones who get paid for their membership interest, nor was DFS empowered to basically rewrite the insurance law. Their only job here was making sure that the plan complied with the law, and they did. And the law, and like I said, the plan is abundantly clear that this is vested in the policyholders. They're the ones that are being paid for their interest. So beyond that, you know, really a lot of this falls on this equitable argument, and counsel made the point that, of all the 4 appellate division decisions, I don't think any of them, at least in the strictly literal sense, said that an equitable cause of action was disclosed. But really, I mean, I don't think it was necessary for the courts to state the extremely basic proposition that a court is not empowered to completely disregard the terms of the governing law in favor of reaching a result that, the hospital in this case, or even the court deems as equitable. Again, I think that's a very basic proposition, and, to argue otherwise is basically to render the law meaningless, and to say that, we don't have to follow the law in any given situation, where we think that the result is unfair. And really the question isn't whether, and it's very clear that the hospital feels that it's unfair that Dr. Hinds received the money, but the operative inquiry isn't whether it's fair. The operative inquiry is whether they've correctly stated a cause of action for unjust enrichment. And in this case, they haven't. And, unfortunately, in my limited time, I can't just recite the decision, particularly the second department in Maple Medical, but I mean, their analysis was spot on. This wasn't money gratuitously paid by the hospital out of altruism. This was part of the consideration in arm's length contractual agreements, an agreement whereby the hospital promised to pay a salary and benefits, including malpractice insurance.
Would it be different if would it be different if it wasn't? What if, like, your parents are paying your policy and they just want to do it to be nice to you?
Well, as much as I love my parents, I don't think they would have any better claim than the hospital does.
A hypothetical. What would happen?
I mean, it would, assuming all other things were constant in the situation, it would depend on whether there was any promise or,
But why is
say
that different?
expectation.
I guess I'm not understanding, and I know this isn't your point, but I'm just not understanding what any formal compensation has to do with anything if you read the insurance law on its face, which says the policyholder. Who cares why you're the policyholder? You're the policyholder.
Yeah, I mean, well, it's not so much the terms of the insurance law. As I said, the insurance law and the plan are clear that the policyholder is entitled to the money. It's the question of whether the hospital can state an equitable cause of action for unjust enrichment, which necessarily requires that Dr. Hinds be unjustly enriched at the hospital's expense. The fact that they
So are
paid...
you saying that you don't, are you saying that you don't stop at the definition in the insurance law? You go ahead, go with equity, even though it says policyholder?
No, Your Honor. I think the definitions in the insurance law and the plan are utterly dispositive of the hospital's claims.
And in that case, it wouldn't matter if it's compensation or not, right?
Well, no, because there might be a theoretical state of facts in which the hospital could be entitled to the money. And this goes to counsel's point. What was the point of the objection procedure if it was this simple? And for the record, DFS in no way stated or concluded that the analysis was not this simple, or that we needed to undergo some fanciful examination of the facts and circumstances to figure out who the rightful recipient was. DFS actually stated in their decision, Insurance Law 7307E3 explicitly defines those policyholders entitled to consideration. I don't know how much more clear they could have been.
But counsel, I'm sorry, over here. It is kind of hard to imagine what the equitable considerations could be if it's as simple as just reading the statute. If it's looking at the statute and determining who the policyholder is in the way that you say it is, there's no set of equitable considerations that I can think of that would entitle the facility to a recovery.
No, I agree with that wholeheartedly. There are no equitable considerations.
So that gets back to that rhetorical question we were asked. What's the point of the arbitral forum that was set up by DFS? Was it just to tell the parties, this is what the statute says, now go home?
No, because there's no way that DFS or MILMIC could account for every set of circumstances in which, or every individual relationship between the parties. Maybe the hospital didn't hear, but maybe the parties did include in their agreement a provision stating that the employer would be entitled to demutualization proceeds, should any arise. Maybe there was more general language, maybe there could be more.
So if I'm understanding your response, counsel, what you're suggesting is that framework is set up for rare instances where there might be a dispute as to whether or not there is an effective designee and whether or not that designee is the employer, or whether or not there is some other arrangement that is recognized by law that's external to the policy that would allow for a claim. Right now, as I understood your adversary, and I asked him a couple of times, really all of his arguments are grounded on the policy and the relationship around the policy. But you're suggesting maybe there would be some other arrangement that would give claim to the employer to that cash, and that's what DFS was thinking about. Am I understanding you right?
Yes, Your Honor, and I maintain that that's the only set of circumstances in which an employer who is not a policyholder could have any entitlement to the money, irrespective whether they...
So your argument is, your argument is that the framework is set up for fact-specific, case-by-case determinations, as opposed to what I understood your adversary arguing for, a bright-line rule.
I'm sorry, Your Honor, I think I was actually arguing the opposite. There is a bright line. The bright line rule is who is the policyholder. And
No. What I'm saying, their bright line rule is the one that they're seeking for, which is if the employer paid the premiums and is otherwise has an indicia of ownership, it's their money regardless of whether or not someone else is the policyholder.
Well, I wouldn't call that a bright line rule, Your Honor. I mean, I'm sure that's the result that they would like, but they're arguing that you need to take a general look at the facts and circumstances of each case. And frankly, the insurance law doesn't provide for that. The plan doesn't provide for that. And, you know, these equitable considerations don't provide for that either.
Thank you, counsel. Counsel,
Thank you.
your rebuttal?
Yes, Your Honor, thank you. Just want to address two particular points. The notion that somehow 7307 is clear and that the language in 7307 that the equitable share is to be determined by the premiums paid such policyholder was merely some formula to assess how much the policyholder is to receive. If that was true, and this is why the statute is not so clear, if that was true, then in instances where the policyholder did not pay the premiums, which is true of the respondent in this case, then the policyholder, if policyholder is so rigidly and narrowly defined, would receive no monies. An absurd outcome that undermines the viability of that interpretation unless this court rewrites the statute and adds language that such policyholder shall receive it if the money is paid by such policyholder or some other third party. But the legislature didn't write that statute in that manner. And as this court has held, courts don't have authority to rewrite statutes. So the notion that insurance law 7307 somehow creates this firm foundation for a viable argument on the part of the respondent runs into a brick wall, as opposed to the hospital's interpretation of the statute, which merely takes you to a place where, well, how do you define policyholder under the statute? Because policyholder is not defined in 7307. But the court has the authority to look for other sources to see how that term is defined. And in the statute, 7307, you have the word person and
So should we give some deference to DFS? And DFS's conclusion that the fact that someone pays the premiums doesn't make them a policyholder?
The DFS did not say that, Your Honor. In fact, the one sentence that they rely upon is immediately preceded by another sentence by DFS where they refer to a commentator who said that whoever paid the premiums is automatically entitled to the monies. And DFS said, no, it's not necessarily so. The court should look at the facts and circumstances surrounding the relationship of the parties. That's why DFS, it's not clear DFS said 7307. DFS did not rely at all on 7307, nor did the plan rely on 7307. Because again, and it's in our papers, I know the court has read the papers thoroughly, but even the plan, the conversion plan, says the opposite of what they're arguing. And makes it clear that the insurance law, the plain language, if you accept their interpretation, takes you to a place where the court would have to rewrite the statute. And that's why going beyond the statute aside from the other authority which allows the court to do so and to take into account equitable considerations. I mean, this court held in Simmons, legal title does not preclude equitable considerations. That's the same framework here.
Thank you,
Thank you,
counsel.
everybody.